in 1998, when the laws changed, things became uncertain. We didn't and don't know whether these two 13-year-olds engaging in sexual intercourse require us to make a report. Because of that uncertainty, I am pretty conservative. I suggest and encourage mental health professionals to CPS about these voluntary sexual activities that we may otherwise consider to be non-abusive, because the law is both silent and the cases have not apparently caught up. And you can ask these questions as hypotheticals for CPS, and if they tell you we're not going to take that report, document it really carefully, okay? But the issue of, what happens when there are two 13-year-olds engaging in sexual intercourse, the sexual intercourse law seems to imply, by virtue of it having excluded kids below the age of 14, that we'd have to make a report. And the case law is about a different section. So I tend to be pretty conservative about making those kinds of reports. Legal definition of close in age. Well, I don't know that there's a specific legal definition of close in age in what I was talking about with this playing doctor exception. The courts seem to be thinking about no more than about a year, perhaps 2 at the most, depending on the age of the kid. 2 is getting out there from my perspective. Those of you who work with latency age children know that the difference between a 5 and 7-year-old is a different planet. And also developmental level of that 7-year-old makes a big difference as well. So age is a rough estimate. Assume that within about a year is okay. If you get beyond a year, you want to be thinking about, are there other aspects of the relationship that make this problematic? Who is initiating the sexual conduct? And if it heads more towards 2 years, you're probably out of the ballpark, okay? So that's as close as I can give you. The courts have not been explicit about this. In your capacity as a high school counselor, you're required to provide a copy of the child abuse reports to the school nurse. Is there a problem that you have regarding disclosing that, since you're an MFT, but you're not hired as that at the school? You are permitted within school settings, when there are a group of people who are required reporters, they're permitted to set up a system for how that report occurs and for storage of the records. So I don't think you're in a problem as an MFT, because even if you were there in your capacity as an MFT, it is not only commonplace, but under the statute, it's legally permitted for a group of mandatory reporters to have a system. And that happens in many situations. For example, all of the teachers in that school setting are mandated reporters. And so they are required, for example, to make a report or to file the report in some instances, in some school districts, with their vice principal, who then takes the responsibility for forwarding those reports to the appropriate agencies and for making the phone call to CPS. So I don't think it would be problematic. And I'm assuming that in part your concern came from what I had written about the change that attorneys are talking about in terms of not handing out forms to anyone but the designated agencies, and not giving a copy of the form to the client or the person who's the victim of the child abuse. And in this case, there are exceptions to that disclosure rule vis-a-vis a large organization such as a school or a hospital, and where they're allowed to set up a process. Are there any justifiable or defensible reasons, for example, suicide risk, for not making a child abuse report which technically meets criteria for mandated reporting? Unfortunately, no. We don't have any defensible reasons on the basis of how the law is currently crafted. There are 3 ways in which we are well, what's a good way of putting this? There are basically 3 sticks that the state uses in the context of child abuse reporting. They say that if we fail to make a report that's mandated, we can be criminally prosecuted for a misdemeanor. We can have our licenses disciplined, which ultimately could, although I doubt in most cases that it would, but it could result in one's license being revoked. and we could also be sued in civil court. There is a reasonable chance that if, for example, we think somebody may become suicidal, that we could win at trial in a civil case and in a criminal case. However, it has been my impression that the board is pretty inflexible in this regard, and they assume that any failure to report child abuse is the basis for disciplinary action. Just to give you an example, there was a psychologist in California, competent, knowledgeable guy who's been very active in our professional organization, who was working with a 12-year-old in the midst of a divorce between the 12-year-old's biological mother and the 12-year-old's stepfather. And the thank you. And the 12-year-old came into this psychologist's office and said, "My stepfather touched me." And then she immediately recanted. And this was in the context of a fairly acrimonious divorce, from what I can gather. The psychologist thought, this is not a reliable report. I'm not going to report this, but we'll keep an eye on things. 6 months later, this child mentioned that to a teacher that she had told her therapist that her stepfather had touched her, and the therapist had done nothing. The teacher reported it to CPS, and the mental health professional was arrested for a misdemeanor failure to report child abuse, incarcerated overnight, from what I understand, and then had to defend a criminal suit. He won. The jury said that professionals have to have some leeway in making judgments. The district attorney nonetheless turned around and forwarded the complaint to the Board of Psychology, that and the Board of Psychology found that the psychologist's defense, what we might think of a reasonably justifiable situation where they did not make a report, was insufficient, and disciplined his license.